37 seconds ago, in a hearing room packed with cameras from every major network, Eric Swalwell did something that made FBI Director Kash Patel's confident expression collapse in real time. The congressman from California's 15th district pulled out a tablet, turned it toward the C-SPAN cameras so millions could see the screen, and began reading from a document that Patel had just testified under oath was permanently sealed under national security protocols. The tablet displayed an FBI classification review form dated February 8, 2025, bearing Patel's digital signature, authorizing the indefinite suppression of 63 witness depositions from the Epstein investigation. But that wasn't what made Patel's hands grip the witness table so tightly his knuckles went white. What made his jaw visibly tighten was when Swalwell swiped to the next page and read aloud the names of 3 individuals who appeared in those sealed depositions: a tech billionaire, a former cabinet secretary, and a sitting federal judge. House Intelligence Committee Oversight Hearing, March 4, 2026, 10:23 a.m. This was supposed to be routine. Annual FBI briefing on cybersecurity threats, election interference preparedness, standard congressional theater. Kash Patel arrived 17 minutes early, flanked by 5 FBI attorneys whose briefcases contained pre-approved responses to every anticipated question. The first 90 minutes proceeded exactly as scripted. Republican members praised operational successes. Democratic members pressed on controversial personnel decisions. Patel delivered his trademark bureaucratic answers, smooth and practiced. Then, at 10:23 a.m., Chairman Mike Turner recognized Congressman Eric Swalwell for his questioning time. The room's energy shifted immediately. Swalwell doesn't ask questions for theater. He asks questions because he already has the answers and the documents to prove them. When Swalwell brings a tablet to a hearing instead of paper files, it means he has digital receipts. Director Patel, Swalwell began, I want to discuss the FBI's handling of evidence related to the Jeffrey Epstein investigation, specifically regarding witness testimony management. Patel's posture remained controlled, but his left hand moved slightly toward his water glass, a micro gesture indicating psychological preparation for conflict. Congressman, the FBI has maintained the highest standards of evidence preservation in the Epstein matter. We've cooperated fully with all congressional oversight requests. Have you? Swalwell's interruption was surgical. Because I have evidence that directly contradicts that statement. He lifted his tablet. This is an internal FBI memorandum dated February 8, 2025. Classification Review Decision. Epstein Investigation Witness Depositions. He turned the screen toward the cameras. Let me read you something, Director. Quote, upon review of 63 witness depositions collected during the Epstein investigation, FBI Director Kash Patel has determined that public release would compromise ongoing law enforcement equities and national security interests. All 63 depositions are hereby classified as permanently restricted, exempted from FOIA disclosure under executive authority. End quote. Signed with your digital authentication. The room went completely silent. Every person present just heard an FBI director get caught in a documented contradiction. Patel's face underwent a visible transformation. His practiced calm flickered for just 2 seconds, replaced by genuine alarm before the professional mask returned. His 3 lead attorneys all leaned forward simultaneously, a choreographed response that told everyone they hadn't prepared for this specific line of attack. Congressman, classification decisions involve complex considerations of witness protection, ongoing investigative integrity, and national security equities that I cannot fully discuss in open session. Swalwell didn't pause. Director, I'm not asking about the process. I'm asking about the substance. He swiped to another document. This is the FBI's own witness protection assessment for those same 63 depositions. It states, and I quote, no witnesses have requested anonymity. No witnesses face credible threats requiring protective measures. No witnesses are intelligence assets requiring classification. The assessment concludes, standard evidentiary disclosure protocols are appropriate. He looked up. So, if your own witness protection team says no security concerns exist, why did you personally classify 63 testimonies as permanently restricted? Patel shifted in his seat, shoulders tensing. The confident lean-back posture disappeared. Congressman, you're reading isolated documents without the full context of interagency coordination and broader intelligence equities. Let me give you context. Swalwell pulled out a physical folder from under his tablet. Blue folder, red classification stripes. This is a list compiled from those 63 witness depositions. A list of individuals that witnesses testified they personally saw at Epstein properties, on Epstein aircraft, or at events hosted by Epstein and Ghislaine Maxwell between 2001 and 2019. He opened the folder with deliberate slowness. The camera zoomed in. These witnesses provided dates, locations, photographic evidence in some cases, and offered to testify under oath in court proceedings. He pulled out a single sheet. This list contains 89 names, Director Patel. 89 individuals that multiple witnesses identified. And you classified every single testimony, naming them as permanently restricted. Patel's face had gone visibly pale. His right hand moved to the table edge. That tell. The one that appears in every hearing when he's about to lie or deflect. Congressman, those classification decisions were made in consultation with Department of Justice officials and intelligence community stakeholders who determined that public disclosure could compromise sensitive investigations and diplomatic relationships. Swalwell leaned forward. Director, I'm going to read you 3 names from this list, just 3. And I want you to explain to me and to the American people watching this hearing what national security interest is served by hiding witness testimony about these individuals. The room held its breath. Name 1, Swalwell read slowly. Technology executive, CEO of a major Silicon Valley company, witnessed at Epstein's Manhattan residence on 6 separate occasions between 2013 and 2015. 2 witnesses provided testimony, both offered to testify in court. You classified their depositions as permanently restricted. Why? Patel's mouth opened, but no sound came out initially. His lead attorney leaned in, whispering urgent advice. Patel shook his head slightly. Congressman, without confirming or denying specific names, any individuals in positions of significant technological or economic influence could present counterintelligence concerns if publicly associated with compromised foreign assets. That's interesting. Swalwell's voice carried controlled fury, because your own counterintelligence division reviewed this exact case and concluded, quote, no foreign intelligence equities identified. Recommendation, standard prosecution protocols. He held up another document. So either your counterintelligence team is wrong or you're lying about why you buried this testimony. The word hung in the air. Lying. Swalwell had just directly accused an FBI director of lying to Congress on camera. Patel tried to recover. Congressman, I take strong exception to that characterization. These are complex judgments involving multiple equities. Name 2. Swalwell cut him off. Former cabinet secretary, witnessed at Epstein's Palm Beach property in 2008 and 2009. 3 witnesses provided detailed testimony including dates, descriptions of conversations, and contemporaneous diary entries. You classified all 3 depositions as permanently restricted. This individual held a Senate-confirmed position in the United States government, Director? What national security interest prevents the public from knowing he was repeatedly at properties owned by a convicted sex offender? Silence. 23 seconds of absolute silence. In congressional hearings, 23 seconds is a confession. Finally, Patel spoke, his voice strained. The individual you're referencing may have been conducting legitimate government business that intersected with ongoing investigations in ways that I cannot discuss in open session. Swalwell pulled out another document. This is that individual's official calendar from 2008 and 2009, obtained through FOIA. Not a single entry mentions Epstein, his properties, or any business that would take him to Palm Beach during the dates witnesses testified seeing him there. He paused. So either the calendar is falsified or your explanation is false. Which is it? Patel had no answer. His lawyers were frantically passing notes, but Patel seemed unable to process anything. His breathing had become visibly rapid. Name 3. Swalwell's voice went quiet, which somehow made it more devastating. Federal judge, currently sitting on a district court, witnessed at multiple Epstein events between 2005 and 2011. 4 witnesses testified. One witness stated they personally heard this individual discuss legal matters with Epstein. He looked directly at Patel, a sitting federal judge, director, someone currently deciding cases, ruling on evidence, determining justice. And you decided the American people don't get to know that witnesses testified he was at Epstein's parties. The room erupted. Actual shouting from the gallery, journalists on their feet, committee members demanding order, Chairman Turner banging the gavel. Swalwell raised his voice over the chaos. Director Patel, I'm going to ask you a direct question, and I want a direct answer. Did you classify these 63 witness depositions to protect powerful people from being exposed as associates of Jeffrey Epstein? Patel sat frozen. His face had gone from pale to almost gray. His hands trembled visibly. One of his attorneys stood up. Mr. Chairman, my client requests a brief recess to review the specific documents being referenced. Request denied. That was Jim Himes, ranking Democrat. Director Patel has had months to prepare for oversight questions about the Epstein investigation. He can answer now. Patel's voice came out barely above a whisper. Congressman, the classification decisions were made according to established protocols with appropriate legal review. Show me the legal review. Swalwell held up yet another document. This is a memo from the FBI's Office of General Counsel dated February 10, 2025, 2 days after your classification decision. Quote, the Office of General Counsel has reviewed Director Patel's classification of Epstein witness depositions. We find no legal basis under current statutes or regulations for permanent classification of testimony that contains no intelligence sources, methods, or ongoing investigative material. We recommend reconsideration of this decision, signed by your chief legal counsel. He set it down slowly. Your own lawyers told you there was no legal basis for burying these testimonies. You did it anyway. So I'll ask again, who were you protecting? At 10:47 a.m., exactly 24 minutes into Swalwell's questioning, Kash Patel completely lost his composure. This is a weaponized manipulation of internal deliberative processes. Patel's voice cracked with panic and anger. You're cherry-picking documents to construct a false narrative that ignores the complexity of these decisions. Cherry-picking? Swalwell's voice rose. Director, I have 127 pages of internal FBI communications about your decision to classify these depositions. I have emails from field agents questioning the decision. I have memos from your deputy director warning that this could constitute obstruction. I have witness protection assessments saying no security concerns exist. And I have your signature on a classification order that your own general counsel said had no legal basis. He stood up. Congressmen rarely stand during questioning. Director Patel, you took office promising transparency. You told this committee the Epstein investigation would be handled with integrity. And then you personally buried 63 witness testimonies that named 89 powerful individuals because releasing them would be politically complicated. That's not true. Patel's voice was barely holding together. Then explain these documents. Swalwell gestured to his tablet and folder. Explain why you classified testimonies your own staff said had no security concerns. Explain why you ignored your general counsel's legal opinion. Explain why witnesses who wanted to testify publicly had their depositions permanently sealed. Silence. Patel sat there, unable to respond, his career collapsing in real time on national television. I move, Swalwell said, sitting back down, that this committee subpoena all 63 witness depositions, all communications regarding classification decisions, all legal reviews, and all records of FBI contact with the 89 individuals named in those testimonies. The hearing devolved into procedural warfare, but none of it mattered. What mattered was the clip. The moment Eric Swalwell methodically proved that Kash Patel had buried evidence to protect powerful people. Within minutes, the video went viral. Swalwell exposes Patel's Epstein cover-up trended worldwide. Legal analysts called it devastating. Even conservative outlets couldn't defend it. And somewhere, 63 witnesses who had been silenced were finally being heard. Because one congressman brought receipts, asked the questions nobody else would, and didn't stop when the answers revealed something terrifying about who gets protected in America. 37 seconds. That's all it took to expose it. One tablet, 3 names, and a question Patel couldn't answer. Why did you bury the truth?